Good morning. My name is Sipra Boyd, and I'm a shareholder with Roberts Markel Weinberg Butler Haley. Happy to see everyone, well, some faces and lots of names. Excited to have you guys join us for our Governing Documents 101 presentation. I'm going to give, I guess, a few seconds for everyone to get in. It looks like we're slowly coming to a standstill with everyone that's joining. In the meantime, I'll get some kind of housekeeping matters out of the way. Like I said, I'm a shareholder with Roberts Markel Weinberg Butler Haley. I am in the Houston office. This particular area of practice has been what I've done for over 15 years now, and it is exclusively what we do. Or what I do, actually. I guess we do a whole host of other things, but excited to be here today with you guys to present on basically a refresher course for many of you that have been in the industry, but then also obviously welcome to anyone that's new in the industry, and hope that this provides helpful information. All right, I think we'll get started. All right, just some more housekeeping issues. The disclaimer, which we all as attorneys like to give, this information that's presented today is based on the law as it exists today on February 8th, 2022, which I can't believe we're already in February of this year. The information is solely for educational purposes and does not constitute legal advice. So if you need legal advice, please get in touch with your attorney and find out more details about the information you learned today. The agenda for today, we're going to cover the following topics: hierarchy of governing documents, kind of just the priority of where the association's governing documents live, how the governing documents are amended, and I'm going to talk about the specific governing documents and the ways in which each one may be amended, and sometimes it's based on the language in the documents, and sometimes it's based on statute. And then we're going to touch a little bit on both deed restriction enforcement as well as collections and foreclosure, which are obviously two of the main aspects of the world of HOA. I will be probably interchanging my terms today. HOA is intended to mean homeowners association. We also use in the industry the term property owners associations, or POA, which is what the Texas Property Code and specifically Chapter 209 uses to refer to HOAs. There's also community associations. I know that I have a handful of people that work exclusively in the single family community association or HOA world, and then also a handful of people that work or volunteer for condominium associations, and there's probably a few that work in both or mixed forms of community association living, and including commercial. So hope to help you guys navigate through all of the basics for each one of those types of community associations. All right, so in terms of the hierarchy, I'm going to go kind of quickly through what the hierarchy or the priority of the governing documents looks like as it relates to generally all associations, but I will point out kind of differences in the way the hierarchy might work for condo associations as well. Again, if there's a specific type of community association that you're working with, the information that you're going to learn today from me may not necessarily apply. It really just depends on your type of POA or HOA. So please reach out to your lawyer if you do have specific questions. Also, one more housekeeping issue that I meant to mention. I will take questions questions and do some answers at the end of the presentation. We're going to use the chat function specifically for that purpose in Teams, and this is kind of a new platform for us, so be patient with us. Well, it's not a new platform for us generally, but it is for the monthly webinars. But we'll try and address some of those questions at the end through the chat function. And if you could try to keep that chat function pretty clear, maybe avoid making comments and just use those for questions, that'll make it easier for me to go through those questions quickly at the end. Okay, so in terms of hierarchy of governing documents, I'm going to use the term dedicatory instruments and also interchangeably with the term governing documents or controlling documents. But dedicatory instruments is a term that's actually defined in the Texas Property Code. It's defined in Chapter 209 of the Texas Property Code, which is where most of the laws that affect single-family property owners associations live. And then it's a term that is defined in Chapter 82 of the Texas Property Code, which is where most of the laws that affect condo associations live. But basically, dedicatory instruments are any instruments, governing documents, controlling documents that affect associations, community associations, and it's generally defined to include every type of document, whether it's a plat or a declaration, your covenants, your bylaws, any rules, regulations, policies. So that's kind of the big term that we're gonna use. The first, typically, at least for single family associations, document that has probably the most importance is the plat. The plat is what is filed initially when a developer or a declarant buys a piece of dirt, and that dirt is really just described with a meets and bounds description. It's not as you know it, or possibly are aware or familiar with it, as the plat that for your subdivision that is divided up in sections or lots and blocks. So initially, when the developer buys this dirt, what happens is the developer envisions what he or she wants to do with the dirt and submits it for recording and for approval through a formal process to make it into a subdivision with plats and sections. And that, again, is typically the initial document that is recorded in the real property records, and it's the framework for the community. It identifies, like I said, the lots and blocks and sections. It might also reference setbacks and easements that are contained in the subdivision, and it's really important for that plat to be filed in the county, recorded in the real property records of the county in which the property lies. So and I'll say this repeatedly, if you're bored one day or one evening and can't go to sleep, I highly encourage you guys to look at each one of these controlling documents, dedicatory instruments, and really pay attention to what's on there. You'll be surprised. After, like I said, 15 plus years of doing this, I'm constantly surprised at what I discover every day that I didn't realize was in a document or a law that's been there probably for quite some time. But the plat does contain some interesting, often restrictions, generally restrictions about the fact that it will be a single family community. One difference, which I will note, is for condominium associations, you will not see a plat that's filed. Typically, when a condominium is developed, it is created by the filing of an exhibit to the declaration, which includes kind of a drawing or a schematic of the buildings, and it will identify in the condo potentially where patios are or what the common areas are and the common elements for the condominium association. So plats typically initially, at least with single family, are recorded first, but not with condominium associations. You don't really see that with condominium associations. The next most important document is the declaration, and everybody on this call probably knows or is familiar with the declaration. The declaration is typically what you will use to base most of what you as a board member or you as a manager determine how and what to enforce as it relates to the community association. The declaration contains kind of the do's and don'ts of the community, what an owner can do, what an owner can't do. And again, the declaration should be filed and recorded with the real property records in which the county, in the county in which the land is for the subdivision. It's again the master document that controls what an owner can and can't do. And again, that's the declaration will be. You'll hear us interchangeably use the terms covenants, CC&Rs, DCC&Rs, restrictions. It's often called by various names, even as it's recorded. There's not a single common name, but the term declaration, I do believe, is also defined in the real property records. The certificate of formation or the articles of incorporation is the controlling document for the community association or the property owners association. And I guess the hierarchy for the documents really does depend on when a document is filed or potentially recorded. And so sometimes you'll see that possibly that the certificate of formation or the articles of incorporation are filed with the Secretary of State's office prior to the declaration being recorded. And that's okay. They're usually two pretty separate documents. The certificate of formation is really the origin document for the community association. So once the developer decides what the name of the community association is going to be, the certificate of formation is filed with the Secretary of State, which incorporates that community association. And that's how it's incorporated in the state of Texas, by filing the articles with the Secretary of State. The certificate of formation usually just really talks about, 5 to 8 particular things: the name of the corporation, the initial board of directors, the initial incorporator, the registered agent of the association, and obviously the main function or purposes of the community association. The certificate of formation is one of those documents that doesn't typically get amended very often unless there's some type of an issue with the actual origination document. And we won't get into that today because this is a 101 class, but there are times, not often, where the certificate of formation may need to be amended. Again, whether or not the articles of incorporation is, in terms of priority, more important or less important than the declaration, they're pretty even. And I would encourage you again to look at when both were filed, and certainly talk to your legal team if you have questions about which one may be, I guess, have more priority than the other. Continuing on with the bylaws of the association, the bylaws provide the framework for the association and really dictate how the actual entity, the community association, functions. And one of my pet peeves, you'll hear me say quite often, is when we're talking about the governance of the association or enforcement of the association, it's really important as board members and as managers to get the terms correct. And you see, I'm kind of stumbling over them, so it's not easy because a lot of them have more than one term, but it's really important to keep the term bylaws separate from the term declaration or restrictions. The term bylaws is really only supposed to be used for the corporate document that determines how the entity functions. And bylaws typically are not filed, or are never really filed, with the Secretary of State, but they are created after the entity is created. And nowadays, the bylaws and information contained about the bylaws is really dictated by Chapter 209 of the Property Code as it relates to single-family associations. There are some provisions in the Chapter 81 and Chapter 82 of the Texas Property Code as it relates to governance for condo associations, not as specific necessarily as Chapter 209. But basically, the information contained in the bylaws has to do with the meetings of the associations, whether it be the annual meetings of the association or the board meetings, regular meetings, special meetings. What is quorum? How much is quorum? What it takes for the association, whether it's a member decision or a board decision, the number that it takes to make a decision. So if it's for a board meeting, a board decision usually takes a majority of a quorum for the board to make a decision. If it's a membership meeting, let's say an election, then at the annual meeting, it'll talk about quorum, and typically quorum is 10%, and a decision by a majority of a quorum is usually what it takes to make a membership decision. So again, another document that I think is really important, and often for whatever reason in terms of how we talk about community associations gets confused with the declaration, is the bylaws, and really important for you guys to, take a look at the bylaws and see what the information is that's contained in there. I will tell you that there are sometimes deed restriction type provisions in the bylaws, and those really shouldn't be in there. Those should really be reserved for the declaration, but you can sometimes find deed restriction type provisions in there as well. Then you have some of the other documents that might come later in time that may or may not get filed by the developer, and sometimes get filed after the fact with after transition and by board members. But architectural control or builder guidelines are often filed, and again, in terms of hierarchy, are lower than the declaration and the articles and the bylaws, because those are typically either adopted by the developer initially when it envisions how the community is going to be developed, or by the board as the community continues to develop and they want to put some safeguards in place. And then there's rules and regulations. Policies, procedures. If you've been in the industry for a while, then you'll notice that several rules and regulations and policies have been necessary throughout the past few legislative sessions to deal with new statutes that have come up. But again, rules and regulations, policies, guidelines, all of those are kind of interchangeable, and they deal with kind of detailed procedure for the enforcement of specific restrictions. They fill in the gaps of sometimes what the declaration provides, but potentially needs to be clarified through an additional document. And then last but certainly not least is statutory law. And that can run kind of from federal law down to local, county, city ordinances and rules. And the way that the hierarchy of how governing documents play with statutory law is complicated. So it's another area where I would absolutely recommend that you contact an attorney if you have questions about whether, a particular law or statute supersedes your governing document. Generally speaking, federal and state law will supersede the governing documents, but there are often times in both the Business Organizations Code or the Texas Property Code that make the statute subject to the governing document. So sometimes you'll see a provision in the law that says, unless the declaration provides otherwise, this is the law. So there, despite the fact that I've said federal and state laws typically supersede, there, in a statement such as that, the statute is saying, look at your declaration first and see what it says, and then come back and look at the law and see what that says, and try and figure out how best to accommodate both of those, and whether or not you can determine which one has higher priority. And obviously there are local laws, county regulations, and city ordinances that impact community associations. Other examples are the FCC, which dictates, satellite dishes, the Fair Housing Act, which there's a federal and state law that dictates what really typically how community associations might respond to a request for some type of an accommodation or a modification due to a disability for a homeowner. And then obviously there's, like I've said, the Business Organizations Code, the Texas Property Code, even the elections code, which we've seen recently, be amended to add provisions about political signage for community associations. So lots of information there, lots of controlling documents and laws. Typically, like I've said, the order of hierarchy is the plat, the declaration, and/or the articles, the bylaws, and then all of these other rules and regulations and policies. And then you've got to throw in your statutory law that gets mixed up in there. Not to forget that there's also case law, which obviously, again, you probably need to rely on your legal counsel, because there is case law that interprets all of this sometimes when a homeowner challenges maybe the application or the enforcement of a statute or a deed restriction. All right, so let's move on after talking about hierarchy to how some of these documents may be amended. Again, this is kind of a cobweb of processes, and each document potentially has a different mechanism in the way it's amended. So it's not necessarily complicated, but it certainly is confusing, and you're probably going to need to rely again on legal counsel to make sure they help you navigate the process, and probably some traps that we've fortunately or unfortunately needed to help community associations get over. So for articles of incorporation or certificate of formation, that controlling document for when the association is created is typically amended by 2/3 of the members. That really depends on the language in of the articles. I have seen many articles that say 2/3 of a quorum of members. That is also what it requires under the Texas Business Organizations Code to amend the articles. But again, it makes it subject to what the articles actually provide. So always look at what your articles say, what your declaration says. Sometimes, oddly enough, the declaration might talk about what it takes to amend the articles, or the declaration might talk about what it takes to amend the bylaws. So you really have to kind of look at the language in all of those documents in order to see which one prevails and which one should be used. Now, sometimes it's not clear and sometimes there's a conflict. So your legal team might offer you a conservative approach and say, look, this is the belts and suspenders. Let's use the more restrictive way, even though we're not entirely sure it's the only way or the right way. But if you have a belts and suspenders approach, then the likelihood that the way that you amend something is less likely, hopefully, to get challenged. But that's the articles, and the articles, like I've said, doesn't often require an amendment, but if it does, 2/3 of all the members, or a quorum of the members, is typically what it takes. The next controlling document, are the restrictions, the declaration, or the covenants. And this one, again, equally confusing. There was an amendment to the Texas Property Code pretty recently that allows now for associations, mandatory associations, to use 209 to amend their documents, depending on what their documents say. So here's another part where you're looking at both the law and what your documents say. But for single family associations under Chapter 209, it takes 67% of all the owners who have a right, who, depending on how your votes are allocated, to amend the declaration, or a lesser percentage if the declaration controls a lesser percentage. Now, that part of the statute, admittedly, is very confusing, and we have internally gone round and round about what that potentially means. For example, if you have a declaration that says it can be amended by a majority of the lot owners, while that may seem like a percentage that's lower than 67%, and on its face it is a majority of all the lot owners, namely each record owner on a deed, a lower percentage than 67% of all the lots. So one vote per lot. And again, this is a 101 course, so I'm not going to get into the details about how messy that can be, but work with your legal counsel to determine whether you can rely on 209 to amend your document, or whether you need to look at your document and the percentage that is required in the document. For condominium associations, it's a little different. Chapter 81 and 82 both have requirements on what it takes to amend a condo declaration. It is 67% of the owners, or a greater percentage if the declaration has a greater percentage and the declaration controls in that event. And condominiums are different because you use typically, again, I've seen exceptions and there's always exceptions, but the aggregate number of the votes. So not all condos and owners are given the same one vote per condo unit. It depends on the size of your unit. And that is obviously dictated in large part by your declaration and how your declaration allocates voting. The bylaws are typically amendable, at least when you look at the language in the bylaws, by either the board alone without a membership vote, or sometimes and oftentimes require a membership vote. Fortunately, for us, there is a provision in the Texas Business Organizations Code that does allow a board to amend the bylaws despite what it says in the bylaws. And we'll touch on that a little bit later. But typically what we believe, and it's our opinion, that the board has the right to amend the bylaws without a membership vote. And like I said, I'll talk a little bit about that. But since it's the controlling document for the entity, and it doesn't really talk about use restrictions and what homeowners can and can't do. It's typically about board meetings and notice and votes. We believe that, the board is probably the better situated to amend the bylaws anyway. And then we have the architectural control guidelines, builder guidelines, rules and regulations. And those, like I said, are all board adopted typically, sometimes developer adopted initially. And those are usually amendable by the board alone without a membership vote. Again, with any of these, I would encourage you to work with your legal team to make sure that you are amending them in the proper method and by the requisite amount of votes, because we as a law firm have handled a slew of cases in which homeowners have challenged the amendment process, and that ties you up in a big legal battle, and it's something you want to avoid. So if you can go through the process with your legal team and do a belts and suspenders approach, sometimes because of the language is confusing, that's really the way to get the best outcome. In terms of where the information lives that I was just talking about, I did again mention that it depends on the language in your documents, but there is statutory authority for several of these amendments. Chapter 209, like I said, which applies to single family associations, has a couple of provisions that are really relevant, which I'll call out. But Chapter 209, Section 209.0041 is where the provision lives that talks about 67% of the total votes allocated to property owners, or a lower percentage if in the declaration there is a lower percentage prevails. And then something to point out that is important in terms of how all of the new statutes and old, and then your documents kind of work interchangeably, is Section 209.0056. If you understand that the concept of amending the declaration typically takes a ballot or some type of a consent that's written and signed, you're usually not going to have a vote at an annual meeting or a membership meeting where the declaration is amended. It's going to be kind of a long process and it will take some time. So keeping that in mind, if you're going to amend your declaration without some type of a meeting, based on the notion that it's going to take a few months or potentially a year, there is a provision 209.0056 that says for an election or a vote not taken at a meeting that you do need to give 20 days notice for that election or vote. So there are timeframes certainly that might impact how you amend a document that are dictated by the property code. So really important, again, to work with your legal team on that. And then in terms of the condominium associations, there are 2 Texas Property Code chapters that apply to condominium associations. And really quickly, again, keeping in mind that there are nuances about each and which applies to your association. Chapter 81 of the Texas Property Code applies to condominium associations that were created before January 1, 1994. That's when your declaration is recorded, that the date. And then Chapter 82 applies to condominium associations that were created on or after January 1, 1994. However, again, some tricks or trips. If Chapter 82, if you look at the applicability section in Chapter 82, there are provisions that apply to pre-1994 condominium associations. So now you've got kind of a patchwork to look at, because if you are a pre-1994 condominium association, Chapter 81 applies, but parts of Chapter 82 might apply if it's a retroactive provision. Regardless, Chapter 81 does have an amendment provision that can be found in 81.111, and then Chapter 82 has a couple of amendment provisions, again, for your post-1994 condominium associations. The amendment of the declaration one lives in 82.067 of the Texas Property Code, and then there's an interesting provision in section 82.070. And again, this is not a retroactive provision. So for all my condominium association board members and managers out there, if you have an amendment to one of your controlling documents that's being proposed, that amendment has to be circulated to the membership prior to the meeting at which that amendment is adopted. And some people miss this because it's kind of, like I said, it's unique only to post 1994 amendment associations, but it needs to be circulated within a really specific time frame. So it's between 10 and not more than 20 days before that meeting. Again, work with your legal team to make sure you're following that process specifically. Okay, now back to the provision that I mentioned in terms of bylaws and how potentially despite what it says in your bylaws, the board could amend the bylaws without a membership vote. If you look at your bylaws today, there might be under the amendment provision that a statement that says only the members or a majority of the members for a vote taken at a meeting may amend the bylaws. Well, that may not necessarily mean what it says. And again, this will sound confusing, but the Texas Business Organizations Code, which also has relevant provisions that apply to nonprofit corporations, can be relied on in certain instances and should certainly be reviewed again with your legal counsel to see if it might apply. But the Business Organizations Code says that the board has the authority to amend the bylaws as long as, and then there's three exceptions, as long as the corporation's charter or certificate of formation reserves, sorry, I say as long as, but it's unless the charter's the corporation's certificate of formation wholly or partly reserves the power exclusively to the members. So now you're doing this flip-flop situation where you're having to look at the articles of incorporation to determine whether or not you can amend the bylaws, the board. But if it exclusively reserves that power in the articles, then that's an exception and you're kicked out of this being able to rely on the Business Organizations Code. The second exception is if the management of the corporation is vested in the corporation's members, which is very unique. Most community associations that we work with, and I've been, again, in my 15 years, have maybe seen one that's like this. The management affairs are typically left with the board. It's a board managed corporation. If the management affairs are left to the members and the members are all the ones that have the right to manage the association, then that's one of those exceptions. And again, you're kicked out of being able to rely on this provision. And then last is if in amending the bylaw, the members expressly provide that the board may not amend the bylaw. So we believe that this means that in the actual amendment provision, it has to say the board may not amend this bylaw, or it has to have an express provision against allowing the board to amend, which is very different than being silent on it or potentially just saying that the members can amend. The reasons why we usually rely on this provision is because amendments to the bylaws, again, are typically not controversial. They might have to do with quorum and your inability to achieve quorum, so you want to reduce the quorum, because if you're not able to achieve quorum, you're not able to conduct business. Potentially how the terms of the directors are laid out or how many directors there are. So really, again, non-controversial type topics are typically what are reserved for bylaw amendments, and that's why we believe typically, again, with all of these exceptions in mind, and work with your legal team again on that the board could amend the bylaws. All right, now moving forward to how governing documents are enforced, and really the main purpose of why you guys are probably all working so hard for your community associations is how do you as board members and community managers enforce the documents and make sure that you have authority to do so? Well, first and foremost, it's important that the documents that you intend to enforce, whether it's a declaration, a plat, a policy, is recorded in the real property records, because there is a statute that says if it's not recorded in the real property records, then it's not enforceable. So really important, if you plan on enforcing a governing document or a provision as it relates to a homeowner and going to battle with that homeowner to make sure that document is recorded in the real property records, or you shouldn't be going to battle. Another important aspect of enforcing governing documents is to make sure that they're available online. This is a new 2021 statutory change to Chapter 207 of the Property Code. If you are an association that is composed of at least 60 lots or has retained a management company, then you have to make your governing documents available online. So management company is defined in Chapter 207. If we can go to the next slide, it's defined as a person or entity established or contracted to provide management or administrative services on behalf of the association. That can mean basically anyone. So if you're self-managed, that means you're contracted with a management company. Regardless of what the definition of management company is, I think if you are in an HOA or a POA with any number of lots, it's really important for you to make sure you make your governing documents available online. So either find a website or someone to help you with creating a website, but make sure your governing documents are easily accessible online. And this also helps with, members that might make a request to review the governing documents because they are, for whatever reason, unable to access them. And that way you can just point them to your online website. In terms of enforcing the governing documents, take a minute to look at your governing documents again and read them. Try to read them in some detail. What is it that I as a board member or I as a community manager need to guide my board in enforcing the documents? What do I need to do to set them up for success? Typically, the functions of the association, per what you can find in the governing documents, is for the board to prepare and adopt budgets, set and collect your assessments, and obviously enforce the restrictions to protect property values, operate and care and upkeep the common areas or the common elements, execute contracts for the community, which might include landscaping or swimming pool contracts, management agreements, any of those business partners and vendors that help you function with the association, hiring staff to perform community tasks, setting rules for the community, and maintaining membership records. Again, going back to the rules, those could be policies and procedures that the association needs to adopt or implement because either they're not addressed in the governing documents or they might help clarify something that's in the governing documents. In terms of enforcement, when we look at the restrictive covenants, the covenants, and I touched on this earlier, and it's on this next slide, but they contain the do's or don'ts of what a property owner can do. So they may state an action that's permitted or state an action that's prohibited on a piece of real property. The restrictive covenants, again, those are your controlling documents as it relates to using the property, not your bylaws, which is the governance, but your DCCRs, your declaration, or your covenants. The covenants also talk about the persons or the entities with the rights of enforcement, and that's a really important provision that we'll touch on later. Examples that we see in your governing documents, which you guys, when I say these, you say, oh, this sounds familiar, but prohibiting non-residential uses of the property, commercial uses, business uses, prohibiting multifamily occupancy like apartments or duplexes, require improvements to be maintained in a particular manner, whether that's landscaping or exterior maintenance, and then requiring architectural review. So obviously, a lot of restrictions have a process by which, before you make any modifications to your property, exterior modifications to your property, you have to go through an architectural review process to make sure you're in compliance with the governing documents. In terms of enforcement, we like to use the enforcement provision as a mechanism to allow other homeowners to potentially understand that they may have the same rights to enforce the governing documents as the association does. Usually, homeowners have the right to enforce the restrictions. Typically what happens, and when this is really helpful, is when there's a neighbor-to-neighbor dispute, for example, a fence dispute or a barking dog dispute, a dispute that doesn't necessarily involve the larger community. If it's really a dispute between those two neighbors, adjacent neighbors, and it's not really impacting anyone, even if it's addressed in your documents, sometimes it's very helpful to look at the enforcement provision and see that the homeowner, any homeowner in the community, also has the right to enforce those documents. So you can nicely, kindly say, we understand, we empathize, we sympathize, we understand that this is a problem that is bothering you, but we encourage you to deal with your neighbor directly on this issue. We can't provide you legal advice on how to do that, but you also have the right to enforce the restrictions. So, please consult with an attorney to determine how that may be done. So, really a useful tool to assist with the community association so that we're not involved in every single dispute as it relates to the declaration and its provisions. One of the enforcement powers that isn't available to homeowners is the right to collect assessments. That typically is only and solely given to the community association along with the lien right. So owners don't have that right, which obviously makes sense, but the community association is the one that has that right. And the purpose for having that right is to create this maintenance fund for the community association. And the maintenance fund is used specifically to assist in the purposes for what the community association was created, whether that may be for maintaining the common areas, taking care of landscaping, your swimming pool, your parks, your playgrounds. It also creates funding for you to enforce your document. So if you need legal fees to go after someone because they're not in compliance with the documents, or if they haven't paid their assessments. So funding of community associations is a really important part of why everyone on this call does what they do and is involved with community associations. Really important, again, to sit down and read your documents, look at your declaration. That's where the ability to collect assessments and the charges that are secured by the lien lives. So really good to understand, well, what are the assessments? What can they be used for? What specifically, what assessment is secured by the lien? Are all assessments secured by the lien? What about late fees and fines and interest? Are those secured by a lien? sometimes charges are not always secured by the lien, and that kind of impacts what you ultimately may or may not be able to foreclose on. And then finally, talking about foreclosure, that leads us into a good segue to the specific foreclosure provisions. And this also changes both by the language in your documents. Your declaration is typically where this lives and really should only live, and the law. So there have been very many changes throughout the years, both to Chapter 209 and the condominium statute that relate to foreclosure. Read your documents to understand when you can foreclose and if you can foreclose. Believe it or not, sometimes you don't have the authority to foreclose. It's very rare, but typically the association's lien does give you the ability to foreclose for non-payment of assessments. But that's when the slide before is relevant. Well, is it just for the non-payment of assessments, or does it include attorney's fees or interest and late fees? What is it that is exactly secured by that lien? And when we're talking about foreclosure, it's good to understand whether this means non-judicial foreclosure or judicial foreclosure, and there are differences. Typically, condominium associations are entitled to foreclose non-judicially, and that means without court intervention, without a judge or a jury stamping a document that says, yes, condo association, you have the right to foreclose. The foreclosure that is done non-judicially is really handled very similarly to how we all know lenders are allowed to foreclose. Lenders are allowed to foreclose based on a deed of trust, and non-judicial foreclosures are handled pretty much exactly the same way. Really, all you have to do is provide a notice of sale, 21 days notice, and then at the first Tuesday following the expiration of the 21 days, the community association can foreclose. Typically, a trustee is appointed. That trustee is usually your law firm or your lawyer, and they will go down to the courthouse and sell a piece of property, a condo unit, to the highest bidder. Single-family associations are a little different. Typically, what we would advise for single-family associations is to only foreclose non-judicially. I'm sorry, I said that incorrectly. Scratch that. To only foreclose judicially. That means with a court order or court approving the foreclosure. You will read in your governing documents, some of you, that the single family association might also have the ability to foreclose non-judicially. That is actually pretty common. But what's happened as a result of state law is that community associations have to go through a judicial process to be able to foreclose non-judicially. So now it's not really non-judicial because you have to go through what's called an expedited foreclosure process, which means you have to file an application in the court and still get some type of a stamp of approval from a judge or a jury on that expedited foreclosure. Once you do, then you can non-judicially foreclose. So it's kind of a fallacy at this point for single family associations to be able to foreclose non-judicially, but again, filled with lots of trips and traps. And so work with your legal counsel to make sure you understand what your foreclosure rights are and when you can foreclose. Sometimes, especially if it relates to deed restriction enforcement, unless in the unique circumstance that your deed restriction enforcement fees and fines are secured by the lien, and even if that's the only issue, we wouldn't recommend that you foreclose, but typically you cannot foreclose for deed restriction enforcement issues. So really important to understand those nuances and the differences between the two, because sometimes we have associations that want to come to us and are really frustrated with an enforcement issue and want the property owner out of there. But unfortunately, we're hamstrung and sometimes can't do that. But we can certainly push the limits and try and get them to comply in different ways. All right, so I'm going to wrap this up and then leave a few minutes for questions, and I'll go through the chat function. But essentially, I can't say this enough. Read your governing documents, and they're complicated, and sometimes they're really long and filled with information that may not make sense, especially if this is kind of your first go around. So go to those 101 classes, educations. This is a great step in understanding what what it is exactly that you're supposed to be doing with that, all that information that you've been bestowed with, but read them and try and challenge all your board members to do the same. Because if you are serving on a board of a community association, if you don't understand what your documents say, then you're basically not living up to the duties that potentially you're bound by under those governing documents. And also suggest to your homeowners that they read them. You know, there's lots of implications when homeowners come at you about what you're doing or not doing, right or wrong. And it's really important for you to at some point be able to say, well, have you read your governing documents? You know, that's not exactly what it says. So challenge your homeowners to read them as well. All right, well, thank you very much. I'm going to take some questions on the chat function, see if we can get through some of these before we run out of time. All right. Can a single family association operate without bylaws is our first question. I guess I would say you probably could, but I would highly recommend that you not. The bylaws are a dedicatory instrument. They are typically something that's recorded in the real property records, or they're not enforceable. And if you don't have bylaws, then you really have a hard time understanding maybe what your quorum is for a meeting, or how often you should be having board meetings. A lot of the information contained in bylaws, I agree, is statutory and can be found in the Texas Property Code or the Texas Business Organizations Code, but it's not all there. So you really need a governing document for your HOA, your entity, to understand how it operates. I'm just thinking of other things, how many board members, what their terms are, you know, how elections might run. Really important things. Boards' duties and powers live in the bylaws. So I guess theoretically an association can operate without bylaws. You won't go to POA prison, but I wouldn't recommend it. The next question, is there an example of when the board has the authorization to amend the articles and or the master declaration without having to obtain approval of 2/3 of the members? Our declaration says 75% of the members. Getting this percentage of votes is extremely difficult to get. So I've never really seen authorization for the board to amend the articles. It's typically 2/3, but I will tell you that a lot of times it's 2/3 of a quorum. So if your quorum is 10%, and that means, you know, 50 homeowners, let's say you're a community of 500, then it's 2/3 of those 50 homeowners. So like I said, there's nuances about how all of that works. So make sure you're working with an attorney to understand actually what the requirement is, because the Business Organizations Code also could impact the requirement, depending on what the language says. Can a homeowner install solar panels without an ARC review? My ultimate answer depends on what your documents say. So unless you have a governing document that requires architectural control approval for solar panels or modifications, which generally all of you do, then the homeowner should be getting architectural control approval before installing solar panels. Now, if you don't have anything else other than you need architectural control approval before making a modification, then what you tell a homeowner about the solar panels and where they go and what color they are and all of that might be impacted if you don't have something else in your governing documents. So in our opinion, important to have some type of a solar panel policy to kind of help a homeowner get through the process of what they can and can't do, even if it's required that they go through the architectural control process. I would say typically they are required, but having a policy helps make sure that the association regulates how those are installed. Is quorum 1/10 of the board members or members of the association homeowners? So I think there's a distinction between what quorum is for a board and what quorum is for a member meeting. So for a board meeting, typically quorum is a majority of the board. So if you have 5 board members, a majority would be 3. and a decision by the board is a majority of a quorum. So you have, of those three, say you have quorum, then you need two of them to make a decision and vote yes one way. And if the other one votes no, that would be a decision of the board. That's for the board. For member meetings, typically quorum is 10%, and that's 1/10 of all the members, all the people that have a right to vote, not the board. So that's the distinction. And for a member meeting, it depends, but typically the quorum is 10%. Yeah, I've seen 20%, I've seen as low as 5%, but typically that's the distinction. Making governing documents available online, can it be only behind the login? Must it be for public, for realtors, and or prospective buyers? The statute isn't, in our opinion, very clear on that. Our recommendation would be to put it on a publicly available part of the website, but you don't have to. I don't think it really speaks to that. If the preference is to put it behind a login, then that's absolutely okay. We don't think that there's a requirement that it be publicly accessible. That used to be the law, and that language was taken out. So in our opinion, potentially an indication that it doesn't have to be publicly accessible, but it may be easier for it to be publicly accessible so you don't have a bunch of people bothering you for requests to review the documents. Can a homeowner enforce the restrictions as an extra measure in a situation where the HOA is giving out fines and violations and the homeowner is not following the rules, such as leaving trash cans out or is parking on the sidewalk, etc.? In my opinion, if the restrictions provide that the homeowner has enforcement authority, then yes, the homeowner can also enforce the restrictions, even if the association is simultaneously enforcing the restrictions as well and levying fines. Those are really two separate entities and causes of actions, and maybe if the homeowner is doing it as well, the homeowner will get a clue that's in violation and do something about it. So yes. Owners have the right to enforce, but can an owner sue the board for not stepping in to enforce the restrictions? That's a pretty complicated question. The quick answer, the short answer is yes. A homeowner can always sue the board for any reason. Now we get to the nitty gritty of, well, is that a valid reason, and how do we get out of this lawsuit? And that's really where the rest of this important question lies. First of all, have directors and officers insurance, because without it, you as a board member are not going to be covered in the event the board does get sued for not enforcing. But the second part of that really depends on the lawsuit. The associations, specifically board members, which is how they conduct business, are statutorily protected by volunteer immunity. And so depending on how a decision was made, or ultimately what the decision was by the board to enforce or not enforce a deed restriction, you could be protected as a board member from a suit. You could have immunity from that suit. However, getting you out of that lawsuit by arguing that you were acting as a volunteer and had immunity and you were operating under the appropriate standard of care, so you should be protected, is again a complicated issue. And I think while I would say statistically we've had lots of success in extracting board members from lawsuits when they are sued for this exact reason, it really just kind of depends on what happened and the specific facts of the situation. But yes, you can be sued for non-enforcing, but typically the association has a right, not the obligation to enforce. And you have to sometimes make a business decision as a board member with your management team and your experts, maybe your attorney, to decide whether or not this is something that you would like to pursue. All right, I'll take a couple more questions. I'm so sorry, we're all out of time. The next question, need clarification on neighbor-to-neighbor enforcement. What does that look like? Using the example of barking dog. Generally speaking, can you explain how handling nuisance isn't something the board has to enforce and what a neighbor has to do? So this is a prime example of where I would say, if a neighbor is coming to you, you really need to suggest that they talk to an attorney, because nuisance is a difficult provision. And so if you don't have anything specific in your documents, using nuisance and relying solely on the nuisance provision to enforce the restrictions, you're going to probably get some pushback from a judge. But if the homeowner is doing it, it's potentially a lawsuit where a judge will give a homeowner some more leeway that's being impacted by this particular issue than it would a community association, because it could be a real big nuisance to this one particular homeowner that's living adjacent to the barking dog. But we should not, as the community association, be giving this neighbor the legal advice. That neighbor needs to be hiring a lawyer and seeking their own legal advice about what that looks like, whether that's a JP lawsuit, what the cause of action is based on, if it's a breach of the restrictive covenants, which covenants, and nuisance might be one of them. Can an HOA be a 501c3? That's a governing documents 201. That's definitely a more complicated question. I've got a lot to say about it, and we don't have enough time to get into it. What I will tell you is they can be a 501c corporation. The answer to whether or not it's valid and feasible will depend on a variety of factors. And I would encourage the association to speak with a CPA to talk about the specific requirements for being for going through that process and applying for that process. There's a bunch of hoops to jump, and I'll tell you, it's not an easy process. And then finally, I'll take one last question. Are title companies required to deliver CCRs to home buyers at closing? Are they required? Sure. At closing, there are a series of steps that need to happen at closing, and depending on whether you're closing on a condo association or a single family association property, whether or not a resale certificate is requested, which one is for condo, it's mandatory for condo associations, but discretionary for single family associations. I would say one of the steps, part and parcel of a closing, is to provide those relevant documents. Now, how does the title company get those documents is something that we all aren't really sure about. But this leads me into, and this is really why I wanted to talk about this real quickly, is there were several new statutory amendments to the Texas Property Code this past legislative year, and a lot of those amendments had to do with a few things, but really the trouble that title companies and realtors are having with accessing information about community associations. Now, while you would say it's all public record, the way that the public record system works, it's not as organized as you would love for it to be. And so it is really difficult if you're not in the community association to potentially find those documents. And that's why now there's a requirement for documents to be on a website. There is now, a requirement for a management certificate to be filed, and for the declaration and any amendments to the declaration to be listed on that management certificate, and for that management certificate to be filed with TREC, the Texas Real Estate Commission. And so if you're not doing all of those, that's when there are problems that result in the closing, and potentially why a homeowner may or may not get those documents. Not that that's an excuse for why a homeowner, might be arguing that they didn't know they had to pay assessments, or they didn't know that this was a requirement, or this was a violation. But still makes it much easier to enforce if we are doing all of those things, and we can point to the fact that those things were in existence when the closing occurred. So a complicated question, or maybe a complicated answer to an easy question, but all of these statutes and the requirements that have led up to where we are today really play a role in what happens at these closings. And so again, really important to work with your legal team to make sure you're in compliance with at least with the last legislative session, and to make sure that people know where they can go to access your documents and information on how to contact the association. All right, well, we're certainly out of time, but really appreciate everyone that joined this morning. Please look for our next webinar. We're really happy and excited to present these to you guys and appreciate all the questions. I think we might be able to get a list of the questions that I didn't get to, and we'll try and send those out along with the PowerPoint presentation. Thank you so much. I hope you all have a great rest of your week.